This important case is about the legal consequences of a court's finding that a provision in regulations or other subordinate legislation is incompatible with the rights protected by the Human Rights Act 1998. That act made the rights protected by the European Convention on Human Rights into rights protected by United Kingdom law. They are referred to as the Convention rights. Our law also draws a distinction between two types of legislation. Primary legislation is contained in an act passed by the United Kingdom Parliament. Subordinate legislation is contained in rules and regulations and other instruments made by other authorities under powers which have usually been given to them by an Act of Parliament. The context in this case is the regulation made by the Secretary of State for Work and Pensions in 2013, introducing what is officially known as the removal of the spare room subsidy, but colloquially known as the bedroom tax. The way that it works is that the regulation prescribes the number of bedrooms a particular household is deemed to need. For example, a couple only need one bedroom, and if they have one extra bedroom, a deduction of 14% is made from their housing benefit. A larger deduction is made if they have more than one extra bedroom. A number of disabled people challenged the validity of the regulation on the ground that, by failing to take account of the special needs arising out of their disability, it discriminated against them in the enjoyment of their right to respect for their private life. In a case called Carmichael, this court decided that where there was a clear medical need for an extra bedroom, which was not catered for in the regulation was incompatible with the Convention rights. It made a declaration to that effect. One of those cases was where a married couple could not share a bedroom because one of them was disabled. Like Mr. Carmichael, RR and his partner live in social housing for which he claims housing benefit. His partner is severely disabled, and it is accepted that they need an extra bedroom for her and her medical equipment. But when the new regulation came into force, the local authority applied the 14% deduction to his housing benefit, as it did with Mr. Carmichael. Like Mr. Carmichael, RR appealed to the first-tier tribunal, which held that the regulation was incompatible with his Convention rights and rewrote it to provide for him. The Secretary of State then appealed to the upper tribunal, which delayed its decision in Mr. Carmichael's case and in a number of Carmichael lookalike cases, including RR's case, until the outcome of the Carmichael case in the Supreme Court was known. Once it was known, the upper tribunal heard Mr. Carmichael's appeal before all the others, and it held that the first-tier tribunal had been wrong to rewrite the regulation, but that the deduction should not be applied because to do so was incompatible with Mr. Carmichael's Convention rights. The Secretary of State then appealed to the Court of Appeal, and all the other pending appeals to the upper tribunal were delayed until the outcome of that appeal was known. The Court of Appeal ruled that not to apply the reduction was not the correct way to remedy the breach of Mr. Carmichael's Convention rights. This could only be done by a separate action for damages under the Human Rights Act. In the light of that, the upper tribunal was bound to hold against RR when his appeal was decided. But having done so, it granted what is known as a leapfrog certificate so that RR could appeal directly to this court, in effect against the ruling of the Court of Appeal in Mr. Carmichael's case. This court rules unanimously in RR's favour. The local authority, in deciding claims for housing benefit, the first-tier tribunal and the upper tribunal in deciding appeals from the local authority, and the courts in deciding appeals from the tribunal, all have a duty under the Human Rights Act not to act in a way which is incompatible with the Convention rights. The Human Rights Act is an act of the United Kingdom Parliament and takes precedence over subordinate legislation such as the regulation in question. The Human Rights Act also draws a careful distinction between a provision in an Act of Parliament which is incompatible with a Convention right and an incompatible provision in subordinate legislation. Thus, Section 3 expressly says that if a provision in an Act of Parliament cannot be read or given effect in a way which is compatible with the Convention rights, this has no effect upon the continued validity and operation of that provision, or of incompatible subordinate legislation if primary legislation prevents the removal of the incompatibility. But otherwise, this means that the incompatible subordinate legislation must simply be ignored. Section 6 provides that it is unlawful for a public authority, including the local authority, the tribunals and the courts in this case, to act in a way which is incompatible with a convention right. But it expressly says that this does not apply to acts which are required by primary legislation or are to give effect to incompatible primary legislation. But there is nothing in the primary legislation in this particular case which requires this regulation or is in itself incompatible with the Convention rights in this respect. Indeed, the regulation has since been amended to provide for people like R.R. and Mr. Carmichael. This case is only about the period between his initial claim in 2013 and the amending regulations in 2017. Accordingly, the appeal against the local authority's 2013 decision is allowed. RR's housing benefit is to be recalculated without making the deduction of 14%, and the reason is that to make it would be a clear breach of RR's convention rights.